resume. Thank you.
Thank you. Good morning to everyone, council and people viewing in the webinar format. We're here for the last day of our judicial review proceedings regarding the definition of First Nations child, or the also known as the eligibility decision. And according to the schedule that was provided, unless there's been a change, I think the order that we'll be going this morning is with the Congress of Aboriginal Peoples, Amnesty International, the Canadian Human Rights Commission, and then the Attorney General of Canada's reply. So if that sounds right, we'll proceed with submissions on behalf of the Congress of Aboriginal People by Mr. Loken.
Justice Fable, if I may, if the APTN can make a sort of a preliminary housekeeping or matter.
Okay, sure.
During our submissions, we forgot to make a request. The APTN is requesting that Your Honor consider releasing your decisions on an expedited basis for this matter. A lot of children and people are waiting for a decision, and we'll just make that request.
Thank you. Yes, I will do my best to do that, of course. Yes, thank you. Mr. Loken, I'll turn it over to you for your submission.
Thank you, Justice Fable. To start, I acknowledge that I'm making these submissions from the traditional territory of the Anishinaabe, Haudenosaunee, and other Indigenous peoples. In my submissions, I will try to do the following. First, I will attempt to answer some questions that you posed in the hearing yesterday. Second, I will address the argument from the Attorney General that there was no evidence or insufficient evidence that non-status children have faced discriminatory barriers. And third, I will briefly address the reasonableness of the decision. So starting with the questions, the first one that came up is this in effect a challenge to the Indian Act, or must it be a challenge to the Indian Act? And the answer is clearly no. I have to confess that there's a certain irony in this for me, because I acted for 15 years as counsel on Daniels, where there was a similar issue, and the position of the Congress was to say we need an interpretation of Indian in section 9124 of the Constitution. Mr. Frater's colleagues kept saying, well, you don't need to do that because it's not going to affect what we actually do. We can program for anybody. We can program in any way we want. It doesn't need to be tethered to any definition of Indian. So it's not going to help you. Now, that was rejected by the courts as a reason not to grant the declaration, but it's markedly inconsistent to now hear that a specific piece of programming, really you just have to go with what's said in the Indian Act. You need to distinguish with respect between two situations. One is where legislation requires that eligibility be tied to the Indian Act. And if that legislative requirement is there, then arguably on any particular administrative decision, you would need to challenge the Act as well. But there is no legislative tether here. There is nothing that requires that the Indian Act be used to bound Jordan's principle. So, for example, if you are unhappy with a decision of the registrar who failed to register an applicant and said, I was just following the Act, well, there you would have to challenge the Act, but not on a case like this where there's no legislative tie. I note that Daniels at paragraph 50 specifically endorsed the idea that the needs of Métis and non-status Indians, they can turn to the federal government to have those needs addressed. The tribunal in paragraphs 262 to 266 dealt comprehensively with this argument of Mr. Frater. The scope of Jordan's principle is discretionary, and as has been noted, Canada already agreed to apply Jordan's principle to some non-status Indigenous people in 2018. So it's difficult to discern what principle they say now precludes them from applying to others. So the second question that came up from you, Justice Fable, is could Canada negotiate over the scope of Jordan's principle? Could it enter into consultations? And the answer that Mr. Frater gave is, well, yes, you can within the interpretive room of the Indian Act. For the reasons I've just given, you're not, the parties are not bound, and neither are you, by the Indian Act. But on the general question of consultation and negotiation, the answer is yes, absolutely. There is nothing in the Constitution or the Indian Act that stops the federal government from broadening the scope of Jordan's principle beyond the Indian Act, and they should do so, consistent with the honor of the Crown. It's noted in many cases that negotiation is the preferred approach to Indigenous Crown relations, most recently in Des Hotels, paragraphs 87 to 89. And by the way, this isn't unique in the human rights context to Aboriginal or Indigenous issues. My friends, for the Attorney General, rely on the case of Hughes versus Elections Canada. One of the things that's noted in that decision is that the tribunal was impressed with the number of orders that Elections Canada consented to. I was counsel for Elections Canada, so I was pleased to see that. But what that shows is that, as with many human rights hearings, the tribunal starts holding a hearing and encourages the parties to work together to see what they can agree on, and then the tribunal can resolve areas of disagreement. This is absolutely standard for human rights. The third question that you asked was about jurisdiction, and Mr. Frater's argument that once the tribunal had decided that it was not going to make a non-compliance order, that it had exhausted its jurisdiction. The answer to that with respect is, well, no good deed goes unpunished. The tribunal, in effect, in terms of the past situation, had some sympathy for Canada because, as the tribunal said, we used the terms First Nations, but nobody had really focused on how far that term went. But nothing stops the tribunal from, at the same time as saying, we're not going to make a non-compliance order with respect to the past. We are going to give guidance on what Canada needs to do in future to comply. So that's all within their compliance jurisdiction. And in addition to that, you see in paragraph 117 of the decision, this is 2020 CHRT 20, that they have a clarification jurisdiction. It's open to a tribunal, that's retained jurisdiction, to clarify what it meant in using the term full measure and scope of Jordan's principle. So there is no merit with respect to the argument that the tribunal lost jurisdiction. The fourth question that you had asked was about identity versus eligibility and Canada's conflating of those terms. I want to simply point out that Canada does a lot of programming outside of the Indian Act, outside of the status population. For the Congress, it's not nearly enough, but it is there. And so we've given some examples in our factum. The post-secondary education benefit is open to Métis, for example. Aboriginal fishing strategy is open to non-status or Indians, not necessarily in the same amounts, but they're eligible. The Indigenous Community Support Fund, which was brought out as a response to COVID, that is one where it was open to applicants who are not just the status population, which makes sense because COVID doesn't ask for a status card before deciding whether to infect someone. Again, you can argue about the amounts, but programming has never been specifically tied to the or compulsory tied to the Indian Act. Friendship centers throughout the country may be funded by the federal government, but they don't require service only to the status population. And I suggest also look at all the definitions of Indian that exist, that are out there in legislation. We have the Indian Act definition. We have a different definition, we know from Daniels, in the Constitution Act 1867, 9124. It's a much broader definition. And we have a different definition again in the Constitution Act 1982 in section 35 sub 2, where Indian is differentiated from Inuit and Métis. And let's remember that Canada is the government that invented the distinction between section 6 sub 1 and 6 sub 2 Indians, and that some people refer to as first and second class status Indians. So we submit that it is, with respect, a bit rich for Canada to say at this point and with this history, oh, we feel that we must stick with the Indian Act definitions because we don't want to mess with anyone's identity. It isn't identity, and it doesn't really lie in their mouth to make that argument. Now, let me move on to the argument that there was no evidence or insufficient evidence that non-status Indigenous off-reserve face barriers to accessing services. We submit that this is not the point. The question was whether Jordan's principle was being applied too narrowly. You can start with the merit decision at paragraph 481. Canada was ordered to take measures to immediately implement the full meaning and scope of Jordan's principle. So the question is, did they or didn't they do that? And there was no judicial review from the merit decision. So Canada is bound by that. And then in 2017, CHRT 14, which is the May 2017 decision, the tribunal set out some principles for what the full meaning and scope of Jordan's principle might entail. And I'm going to refer to three of them. One is that Jordan's principle applies to First Nations children, whether on or off reserve. And that's in paragraph 135, sub 1. Sub 4, the government will still evaluate requests even if they are beyond the normative standard of care, because they're looking through a substantive equality lens. And finally, principle 5, dispute amongst government departments or between governments is not a required prerequisite. Now, in this case, Canada did seek judicial review, but that judicial review was resolved on the basis of some tinkering with the language that left those principles intact. So those are accepted principles. Canada cannot, in this court, look behind them. It can't say that the tribunal strayed when it started considering off reserve, or it strayed when it went into the idea of non-normative standard of care and substantive equality. It has bought into those principles. So we say that rather than, was there enough evidence of barriers? The question is, in the exercise of its remedial discretion, can the tribunal order that non-status off-reserve children are eligible on a case-by-case basis? That's the question they directed their minds to. Now, for several reasons, we say the answer is yes. Starting with the general, remedial discretion is broad and is entitled to a very high degree of deference. It's a discretionary decision. Secondly, the tribunal's remedial jurisdiction is not just to remedy past discrimination, but also to prevent the same or similar discrimination or discriminatory practices in future. That's in 53 sub 2, paragraph A of the Act. And the tribunal specifically cites that similar practices in future jurisdiction at paragraph 263 of its decision. The Supreme Court has said that human rights remedies are to be flexible and imaginative. And that's in the Communauté Urbaine de Montréal decision. And that's cited in our factum at paragraph 31. And there was ample, we say, legal and evidentiary basis for the tribunal to conclude that the full measure and scope of Jordan's principle should reasonably include non-status Indigenous children off reserve in the categories that they did. First Nations children, it was accepted by Canada, may have needs that go beyond the normative standard of care, and they may need culturally specific services. In the definitions or eligibility decision itself, the paragraph 10, the tribunal relatively early cites the unchallenged findings of the merit decision, and those include that First Nations children may need additional services that other Canadians do not, that they struggle with intergenerational trauma of the residential school system, poverty, the legacy of colonialism. There was specific evidence of Dr. Bombay on intergenerational trauma, and none of this is limited to the status population. The panel also had evidence of the discriminatory foundations of the Indian Act, its assimilationist purpose, and long history of arbitrary exclusion. And that was in Dr. Malloy's evidence, as reinforced by the findings of prior cases in the courts and the tribunal itself. And the panel addressed the discriminatory background and operation that the Indian Act can work at paragraphs 165 to 172. The panel had evidence of the illustrative case, as it referred to, of SJ, who was denied medically necessary services because she was non-status off reserve. And even Canada's witness, Monsieur Perron, he endorsed looking at substantive equality and going beyond what the provinces do as being fair because of past disadvantage. That was Canada's witness. And the reference to that is the Attorney General's Compendium, Volume 1, Tab 25, page 417. I note also that the tribunal's conclusion is consistent with the Daniels decision, where the trial judge found that non-status Indigenous are among the most disadvantaged groups in Canada and are subject to discrimination. That specific citation is in our factum at paragraph 19. The tribunal, in its decisions, met all of Canada's arguments head on, and they're the same arguments as are made in this court. At paragraph 178, you'll see the tribunal explaining that it's not drafting policy, it's analyzing the responsiveness of the government's approach taken to implement the panel's orders to cease its discriminatory practices and to provide guidance to eradicate residual discrimination. The tribunal's interpretation, it says, is through a human rights lens, and its focus is to ensure that its orders are effectively implemented in a non-discriminatory manner. Indeed, I'd go further. If the panel was to have ignored the potentially discriminatory manner of what Canada urged them to do, it would have made an error of law. But it went with its focus on the interpretive lens of ensuring non-discrimination. The tribunal is entitled to focus on substantive equality. That's an approach Canada endorsed in deciding what the full measure and scope of Jordan's principle should include. Now, let me move on for my last few minutes to the reasonableness of the decision. And there's the two categories. Firstly, non-status First Nations children claimed by the First Nations as citizens or members. There was, put simply, an overwhelming case that this category is necessary to include, to respect self-determination, UNDRIP, treaty rights, and the modern trends in case law under Section 35 and otherwise. The tribunal in this section properly referred back to the principles of substantive equality that it had already said it was relying on. You'll see that in paragraphs 214 and 215. And the result is linked to that as well. They're not going to include these children automatically. It's going to be case by case. They're going to assess for what services are required, whether the province provides them, and whether the child's needs the child needs services that are above normative standards. Again, going back to that evidentiary basis. That's in paragraph 214. So that has all the hallmarks of a reasonable decision reasonably reached. Now, as for the non-status children of a status parent or guardian, again, the tribunal refers back to the substantive equality and its previous findings. You'll see that particularly in paragraphs 238 and 239. The goal of the tribunal, the goal of Jordan's principle was to access services that are culturally appropriate and account for intergenerational trauma and other relevant specific needs that may only be addressed through services that are above normative standards. So the tribunal was completely aware of the idea that a non-status child off reserve can likely access provincial services, but that doesn't answer the question, what if there are needs for above normative standards because of intergenerational trauma, the legacy of colonialism, et cetera, et cetera. At 239 says that it's going to be based on actual needs for services that go beyond normative standards and are rooted in historical and contemporary disadvantage. This was not a blank check. This was a focused decision that followed the logic of the merit decision and followed the logic of Canada's endorsement and the tribunal's ruling on a substantive equality approach. Again, the tribunal refers back to the discriminatory impact of the Indian Act, in particular section 6 sub 2, and that's in paragraphs 253 to 268. The tribunal could have gone further than the first generation of section 6 sub 2 Indian status people, but didn't. So it was restrained in that sense. So this is a case-by-case, needs-based, substantive equality-focused decision that is a reasonable outcome based on a rational and intelligible chain of reasoning. It is, of course, not for this court to reweigh the evidence or to find fault with isolated paragraphs. The reasons as a whole, we submit, are cogent and compelling. So subject to any questions, I think I've been exactly 20 minutes, and those are my submissions.
Thank you, Mr. Loken. No, you've answered a question that I had written down for myself. Thank you for that. I don't have any more questions. Thank you. We'll now hear from Amnesty International and Mr. Aylward.
Yes, thank you, Your Honor. Mr. Frater said yesterday that no amount of international law would be able to persuade him of the reasonableness of the tribunal's decision. So I don't hope to convince Mr. Frater of anything this morning. But nonetheless, I do hope to show that international law principles are highly relevant to an evaluation of the reasonableness of the tribunal's decision with respect to the definition of First Nations child, and in fact imposed constraints on the tribunal that would have been unreasonable for the tribunal to ignore. Now, I spoke the other day about the legal framework for applying international law to a reasonableness review of the Human Rights Tribunal. I don't intend to repeat myself on those principles, but I would refer back to them because they're as applicable here as they were in the other, in the context of the other judicial review. And similarly, some of my friends have already spoken about principles of international law relevant to this case, and I will endeavor not to repeat anything that has already been said. This morning, I would propose first to look at the tribunal's decision in respect of its treatment of international law, and then turn to the broader international legal principles that inform the analysis, and in particular with reference to the principle of self-determination. And then finally, I'll conclude with some comments about the application of those principles to the decision by the tribunal in this case. So turning first to the decision in the First Nations Child decision, or the eligibility decision, 2020 CHRT 20, the starting point for the tribunal's analysis was in its finding in the merits decision that there had been discrimination against First Nations children on and off reserve with respect to the implementation of Jordan's principle. The tribunal recognized in the eligibility decision at paragraph 216 that it was required as a matter of international law to craft an effective remedy for that violation. And moreover, both as a matter of international law, and I would think of common sense, that an effective remedy for a violation of human rights couldn't itself be a measure that infringed broader principles of international law. That to be effective, that it must be consistent with Canada's international legal obligations. The group that has been discriminated against, as found by the tribunal, was First Nations children on and off reserve. And the finding wasn't limited to First Nations children on reserve or with Indian Act registration or the specific categories submitted by the Attorney General for Canada. That depends highly on the Indian Act. So that was the group that had to be the subject of the remedy, which leads to this difficult question that many have addressed the challenges in trying to come up with an answer to this question of, well, what is a First Nations child? The tribunal's decision approached this question with sensitivity and with consideration of the principles of self-governance and self-determination that have been recognized in international law, in particular as they apply to Indigenous peoples. And the discussion is fairly lengthy. Again, paragraphs 136 to 157 in the tribunal's decision reviews those issues. And the tribunal concluded that it would violate principles of self-determination to use a definition of First Nations child that is rooted in the Indian Act as a state-imposed definition of indigeneity. The right of self-determination and related principles of self-governance and self-identification, which is the key to who belongs to the group that is to be self-determined, are well established as a matter of international law. My friends from the AFN and COO yesterday have already addressed some of these principles. So I'd just like to highlight a couple of aspects of these principles. First, that the principle of self-determination is now codified in the UN Declaration on the Rights of Indigenous Peoples, so specifically Articles 3, 4, and 33. And self-identification, the identification of the members of those Indigenous peoples, has been central to the UNDRIP and to the development of self-determination as a concept in international law. Indeed, the UNDRIP itself does not include a definition of Indigenous peoples. And that wasn't just an oversight, it was a deliberate decision to leave out a single definition in order to make room for self-determination, which itself is a principle recognized in the UNDRIP itself. And human rights bodies have followed that lead and have consistently refused to formulate a single definition of what Indigenous peoples means. Before the UNDRIP, the UN Declaration on the Rights of Indigenous Peoples as a declaration is intended to declare the status of international law, of customary international law. And it does so by reference to pre-existing principles. And so this is a well-established concept in international law prior to the UNDRIP. The International Court of Justice recognized in the East Timor case, just referenced in our factum, that it was one of the, quote, essential principles of contemporary international law. And a number of scholars have recognized self-determination as being a principle that has risen to the level of being a peremptory norm, or jus cogens, that is a norm from which states may not derogate. So, and we refer to a number of other relevant international legal concepts in our memorandum, including the best interests of the child principle and the right to culture, as those relate to this definitional issue. I'll just rely on our memorandum for those points as well. In terms of the application of these principles to this case, I'm going to pick up on Your Honor's question from yesterday and Mr. Locan's response this morning, but specifically through an international law lens, which is that the Indian Act does not require the CHRT to fashion remedies that apply the registration criteria under Section 6 of the Indian Act. So there's nothing in the Indian Act that prohibits the CHRT from crafting a remedy that requires Canada to provide services to First Nations children who live off reserve without Indian Act registration. From an international law perspective, and from Canadian implementation of international law, the rule from HAPE, the Supreme Court of Canada's decision in HAPE, is that domestic law must be interpreted to conform with international law, except where there's a clear intention expressed by the legislature to depart from international law. And so the Indian Act approach to defining First Nations is clearly inconsistent with principles of international law of self-determination and self-identification. But in the case of the Indian Act, the legislation expressly requires INAC to apply the criteria in Section 6 when making decisions about registration. So there's specific legislative authorization that permits Canada to depart from what otherwise would be its international legal obligations that would be that would inform the interpretation of domestic law. But there's no equivalent here. In other words, Canada doesn't need permission to depart from the Indian Act registration status. It needs permission to apply them in the form of clear legislative language, and that legislative language doesn't exist in this case. This isn't a situation where the Human Rights Tribunal ordered INAC to register First Nations children who would not be eligible for registration under the Act. That would be a clash, but that's not what happened here. And finally, I would just note that this is a particularly significant consideration in this case in light of the nature of the discrimination that was found, of the discriminatory harm, which itself was tied to the harm done to First Nations children from overly rigid line drawing and jurisdictional squabbling that interfered with the provision of much needed services. And so with that, I would submit it was entirely appropriate for the tribunal to take a robust and purposive approach to remedying the discriminatory harm against the group against which that harm was committed. Subject to any questions, those are my submissions.
Thank you, Mr. Aylward. I would like to hear your thoughts on just a little bit more elaboration on the application of UNDRIP in this particular case. Just flesh it out a little bit for me from your perspective.
Sure. So, as I say, the UNDRIP is declaratory. So it's declaratory of customary international law. And we know from the Supreme Court's decisions in HAPE and Nevson and various other decisions that principles of customary international law don't require implementation by legislation in Canada. They form part of the common law. And in that respect, they inform both the interpretation of legislation. So if you want to look at it as a matter of interpreting the tribunal's remedial powers under the Human Rights Act, or as being part of the common law that imposes constraints on what counts as reasonable in terms of a discretionary decision by the tribunal. But either way, the effect of UNDRIP is to recognize internationally, and Canada has fully signed on to UNDRIP and agrees that it represents the state of international law, that these principles of self-determination and self-identification do form part of customary international law, and to that extent operate as a constraint on what the tribunal is able to do.
Thank you very much. That was my only question. I thank you for your submissions and for answering the question.
Thank you, Your Honor.
That brings us to the Canadian Human Rights Commission, and I know there's two counsel, but it looks like Mr. Smith is the one going to be presenting.
Yes, Justice, thank you. That's right, it's Brian Smith on behalf of the Human Rights Commission. I am pleased to again be joined by my colleague, Jessica Walsh, but I will be making the Commission's submissions to you this morning. So I would like to begin by acknowledging that I'm currently in Ottawa on the unceded and traditional territory of the Algonquin Nation. And Justice, it's become clear over the week that you've read and paid careful attention to the parties' written materials. And from that, you would have seen that the bulk of the Commission's written submissions focused on matters that were common to both applications, such as standard of review, judicial review remedies, and also, frankly, on the compensation decisions. They got a bit more time in our written materials than did the First Nations child decisions. And less was said about matters that were unique to the decisions that we're talking about today. In reviewing that material to get ready for this morning, I've also realized that much or even most of what we did have to say about the First Nations child decisions has already been covered in one form or another, either in my submissions on Wednesday or in the submissions of other respondents yesterday and this morning. So I'm going to do my best to avoid duplication this morning. And with that in mind, I do not plan to walk you through the record or the decisions. Others have covered that ground in much detail. Instead, I'm going to try to hit just some main points where we feel we may have something to add. And it will all be with a view to establishing that the First Nations child decisions are reasonable and that this application should be dismissed. So we've all been diligently counting our points all week. I think I have 9. We'll see if I turn out to be right. But I do think I will probably be less than my full allotted 45 minutes. So let me turn to my first point, which is, again, back to standard of review. So you have our general submissions on standard of review from Wednesday and from our memorandum, and I won't repeat all that today. I will invite you to bear those submissions in mind in the context of this application as well. But I did have one new point that I wanted to make in response to something Canada said in its submissions yesterday. So at one point, Canada mentioned to you that it had included in its condensed book at tab 26, 3 Federal Court of Appeal cases that discuss Vavilov. And these were cases decided after the delivery of Canada's memorandum. Kattenberg was one case, which we also referred to on Wednesday. Sexsmith is another, about which I have nothing to say. But the third was Canada Attorney General versus Ennis, which is at tab 26B of the Attorney General's or Canada's condensed book. And I did want to say a few words about Ennis. And Counsel for Canada will surely let me know in reply if I heard this wrong. But I thought I heard Canada cite Ennis for the proposition that where a tribunal asks itself the wrong question, the resulting decision will be unreasonable. And with respect, while Ennis is a very instructive case, it doesn't stand for that proposition. So we're quite familiar with the Ennis case here at the Commission. It was actually an application for judicial review of a decision that was made by the Commission about whether a human rights complaint should or should not be sent to the tribunal for inquiry. And the Commission decided that the case should not be sent. The complainant sought judicial review, arguing that the Commission's decision was unfair and unreasonable. And the federal court found the Commission's decision was to be reviewed for reasonableness under Vavilov, and it overturned the Commission's decision, finding it had been unreasonable. The Attorney General of Canada was representing the respondent in that case, and the respondent appealed to the Federal Court of Appeal. So what you have in the Attorney General's condensed book is the Federal Court of Appeal's decision, which overturns the federal court decision and thus restores the Commission's original ruling with respect to the complaint. So this was not a case where an administrative body made an unreasonable error by asking itself a wrong question. To the contrary, Court of Appeal upheld the administrative decision at issue, finding the Commission had given cogent reasons in support of its conclusions. What the Court of Appeal actually said was that it was the federal court that had committed a reversible error by asking itself the wrong question under Vavilov and by effectively conducting a correctness review. And you'll see that in paragraphs 48 to 53 of the Court of Appeal's decision. And I won't ask you to turn it up, but I'll say a few words about it. If you do look there, you'll see that the Court of Appeal begins by reproducing paragraph 83 of Vavilov. And that's a passage you've heard a lot about this week already. That's the passage where the Supreme Court says courts sitting in review should not ask themselves what decisions they would have made in the place of the administrative body. It's also the one that has language that I know I mentioned on Wednesday, saying courts should not make their own yardsticks, then measure administrative decisions against those yardsticks. So after reproducing that passage, the Court of Appeal says that instead of taking the approach encouraged in Vavilov, the federal court in Ennis started effectively by asking itself how it would have ruled on the question that was before the Commission. And then paragraphs 50 to 51 of the Court of Appeal decision set out the crux of the matter. And they're short, just a few sentences. I'm going to read them. So this is quoting now from the Court of Appeal in Ennis, talking about the federal court's decision. And the Court of Appeal says, with respect, this approach is erroneous. It is not for the federal court or this court on appeal to question whether there was sufficient evidence before the Commission to warrant referral of Mr. Ennis's complaint to the tribunal for inquiry. Such a question is identical to asking whether the Commission was correct in its conclusions as to the sufficiency of evidence. This is correctness and not reasonableness review. So that's paragraph 50. Court goes on in paragraph 51 to say this. Under reasonableness review, contrary to the approach taken by the federal court, the question for the reviewing court is rather whether the Commission's determination that the evidence was insufficient is a reasonable one that it was open to the Commission to have made. In asking itself the wrong question, the federal court fell into error. This led to its erroneously re-evaluating the sufficiency of the evidence that was before the Commission. So I'll stop there, simply to say that in our view, there's nothing about the Ennis decision that calls into question the reasonableness of the First Nations child decisions here, or the compensation decisions for that matter. And to the contrary, we say the Court of Appeals approach is entirely consistent with what is being urged on you here by the Commission and other respondents, an approach that would begin with a careful examination of the administrative decisions, and that would show the deference that is properly still required on reasonableness review. Moving to my second point, remedial methodology. So earlier this week, I mentioned my plan to say a few words today about the remedial methodology the tribunal has employed consistently since the merits decision. And so this is the process in which the tribunal makes decisions, providing guidance, directs parties to consult to see if they can reach agreement on how to implement the decisions, and retains jurisdiction to make such further orders as may be needed to ensure effective implementation. So on Wednesday, I said a number of things about this in response to your question, and I mentioned a few reasons why the Commission believes that approach is reasonable. It's consistent with the wording and remedial purposes of the statute. It's been endorsed by this court and applied by the tribunal in other cases. And it has the potential to promote reconciliation between the Crown and First Nations peoples. But I did have two additional things I'd like to throw into the mix, if I may. The first is just to observe that the tribunal first adopted this approach to remedies, in this case, all the way back in the merits decision in 2016. And it reaffirmed and followed that approach many times over in the years between that merits decision and the decisions that are now at issue in these applications. So just to give you some citations, 2016 CHRT 10, 2016 CHRT 16, 2017 CHRT 7, 2017 CHRT 14, 2017 CHRT 35, and 2018 CHRT 4. These are all decisions or rulings which include features or hallmarks of this, what we're calling this dialogic approach. And aside from one narrow matter that was later resolved on consent, Canada did not seek judicial review of any of these series of rulings. And we say that this is relevant context when weighing the reasonableness of the tribunal's decisions to continue with that same methodology when dealing with the compensation and First Nations child issues. The second thing I wanted to say about this methodology is really an acknowledgement. So just want to acknowledge that taken as a whole, the dialogue in this case has been long. Not many cases are still active in this way, 5.5 years after a liability decision has been reached. And so I can appreciate that to some observers, this would appear unusual, especially when compared, for example, to the typical progress of a civil court case, where judges would rarely retain authority to oversee the implementation of their orders. But it's in this context that I wanted to go back for a moment to a key passage from Vavilov. And this is paragraph 92, which among other things cautions reviewing courts to remain acutely aware that administrative justice will not always look like judicial justice. And so the Supreme Court made that comment in a section of the decision talking about the content of reasons. But we think it has equal resonance here when thinking about the process the tribunal has directed as a means of arriving at its final orders. So while this dialogic approach might seem odd or unusual to a civil litigator, it is not unusual in the statutory human rights context. And it is okay for statutory human rights claims to follow a different path. Looking to the Canadian Human Rights Act, we can see indications that Parliament intended to create a tribunal that would be less formal and more flexible than a court. This is why, for example, Parliament chose to relax the rules of evidence in tribunal proceedings. And you've heard about this earlier this week. The tribunal has express power to admit and rely on any evidence it sees fit, including hearsay evidence, regardless of whether that evidence would be admissible in a court of law, subject only to considerations about privilege. So provisions like these are strong indicators that Parliament intended for the tribunal to function differently than a court, all with the goal of promoting access to justice for the vulnerable groups who require the Act's protection. And so we say this principle extends into the remedial realm, and it further supports this notion that a dialogic approach has been reasonable and is, in fact, to be preferred in cases where discriminatory practices are deeply entrenched and respondents have shown themselves over time to be resistant to making necessary changes. My third point is about the nature of the claim, and I'll be, I think, pretty brief here. Canada has continued to argue that the complaint as filed and as framed at the outset focused on the Child and Family Services Program on reserve and in the Yukon, and the suggestion is that it was therefore improper for the tribunal to engage in the First Nations child decisions with matters relating to Jordan's Principle and its application to non-status children off reserve. And we've already said in our memorandum, paragraphs 119 to 124, that we do not agree with that position. I won't go through all that in detail today, mostly because the Caring Society and others have covered this ground in some detail. Just want to make clear for you that we do endorse the submissions that have already been made in that regard. We agree that Jordan's Principle has always been within the scope of the pleadings at the tribunal. We agree the tribunal has already made unchallenged findings that Jordan's Principle forms part of this inquiry and applies on and off reserve. And we agree that Canada should not now be allowed to take positions in relation to the First Nations child decisions that depart from findings already made in those earlier rulings. And indeed, in our memorandum at paragraph 123, we closed our discussion here by saying that in our view, questioning those findings today would be tantamount to allowing an improper collateral attack on the earlier rulings of the tribunal. So I'm going to move to my fourth points, which are about the reasonableness of the outcome and the reasons. So in the proceedings below, the Commission did not take a position on the meaning to be given to the term First Nations child. Instead, we generally urge the tribunal to apply a human rights framework when analyzing that question. One that would take into account principles of self-government and self-determination as recognized in domestic and international law. And as explained in our memorandum at paragraphs 125 to 131, we believe the tribunal did exactly that, providing cogent reasons in support of reasonable outcomes. So in this regard, a typical human rights framework for considering whether eligibility criteria are discriminatory, in our view, involves a series of steps. One is to identify the nature of the benefit being sought. Another is to examine the purposes for which the benefit is being provided. And another is to ask if the eligibility criteria that are being used would exclude persons who fall within those purposes from receiving the benefit for arbitrary reasons that are linked to prohibited grounds of discrimination. So that's set out in our memorandum, and it's, we say, reflected in the First Nations child decision at paragraphs 231 to 235. And we say that overall, the tribunal's reasons show that it was alive to these issues and reasonably dealt with each one in turn. So in terms of the benefit at issue, and you've heard this multiple times, I just want to state my agreement with this. The tribunal stressed two important things. First, the issue related solely to determining who is a First Nations child for purposes of Jordan's principle, not for any other purpose, such as membership or citizenship. And that's in the tribunal's decision at paragraphs 84 and 129. And that's an eminently reasonable conclusion. The tribunal also was clear that the benefit being sought was an entitlement to be considered for the possible provision of services. So in other words, the benefit was that of being able to apply for services and to have the request considered on a case-by-case basis in accordance with existing substantive equality principles. And that's set out at paragraphs 213 to 215 of the First Nations Child Decision. Other respondents have already talked at length about why those findings are reasonable, and we agree, and I don't have anything further to add on those particular points. Continuing to move through that human rights framework, another step is to identify the purposes for which the benefit in question is being provided. And here there was actually very little left for the tribunal to do by the time the First Nations Child Decision came around, because it could simply draw on past unchallenged findings, which had already reached final conclusions that Jordan's principle serves two broad purposes. It ensures First Nations children can access needed services without experiencing gaps, denials, or delays. And it enables First Nations children to access services that are culturally appropriate, that are safe, that account for intergenerational trauma and other relevant specific needs, and that may exceed normative standards. So in paragraph 128 of our memorandum, we give you pinpoint citations to the decisions where you can find those concepts reflected. And again, we say that those findings are reasonable based as they are on past rulings that were unchallenged. Now, having identified and discussed the benefit at issue and the purposes for which the benefit exists, the tribunal considered whether the use of Indian Act registration as a necessary criterion for off-reserve First Nations children was consistent with the Human Rights Act and its prior rulings. And we know the results. You've heard about this in detail. The tribunal found there were two categories of First Nations children who had been excluded in ways that were discriminatory under the Act. But it also did reject a request to include a third and broader category. So it wasn't the case that the tribunal granted all the relief that had been sought. It did a careful look and made what we agree were reasonable findings. And of course, you've already heard other respondents discuss those findings in detail, including their basis in domestic and international law. And we agree with them in that regard, and again, have nothing further to add on that point for this morning. This brings me to my fifth point, which is about this question about non-compliance. So as you've heard, the tribunal acknowledged in the First Nations Child Decision that its earlier rulings had not given precise meaning to the term First Nations child. And it therefore said that it did not think it would be fair to Canada to make a finding of non-compliance. And that's in paragraphs 114 to 117 of the ruling. So in fact, you've heard the Congress of Aboriginal People speak about this morning. Canada has said that once that finding was made, it should have been the end of the story. And so we disagree. And actually, we find ourselves in agreement with the Congress of Aboriginal Peoples on this point, and I think the Caring Society and others as well. Reading the tribunal's reasons as a whole and in context, it is apparent that in declining to label Canada as non-compliant, the tribunal did not mean to say that there was no further guidance necessary. Instead, the tribunal was simply acknowledging that the past rulings had not provided clarity on that point, since no party, including Canada, had asked it to do so. So in those circumstances, it was reasonable for the tribunal to say that it was not prepared to use language suggesting any kind of intentional breach or moral culpability on the part of Canada. But that did not leave the tribunal powerless. Where the tribunal retains jurisdiction, it does so in order to ensure its prior orders are effectively implemented. So where an order is made and parties later discover that there is no agreement on the meaning of a key term, it is entirely appropriate for the tribunal to exercise its retained jurisdiction to resolve the question. And that is all that has happened here. And we say it was reasonable. And, one is left to ask, what would the alternatives have been if the tribunal had not gone on to provide this clarification? Well, for one thing, a claimant party could have tried to start enforcement proceedings against the department or the government in the federal court. However, it's questionable whether that could have succeeded, since, as the tribunal reasonably acknowledged, there was ambiguity in the term that needed to be resolved in the absence of an agreement among the parties. So what else might have happened if the tribunal had turned the parties away? The Caring Society or another party might have filed a fresh human rights complaint at the commission, arguing that Canada's interpretation of the tribunal's order was producing discriminatory results. So what would have happened here? This would have required initiating a fresh administrative process. It would have meant a fresh complaint to the commission, an assessment by the commission, a statutory decision by the commission about whether to refer that new complaint to the tribunal. If it was referred to the tribunal, there would have to be a panel assigned, which might be the same or a different panel. There would have to be the delivery of pleadings, the exchange of disclosure, then a hearing on the merits and a ruling. So that's a long process. And in our view, it's not a realistic or efficient alternative. When the expert panel here was available, had retained jurisdiction over its remedy, and remained seized with numerous other interconnected matters. So all that's just to say that we support other respondents in saying that the tribunal reasonably proceeded despite its decision not to label Canada's conduct as non-compliant. That brings me to my sixth point, just to speak a little bit about the relationship of the First Nations child decision to the compensation rulings. So you've already heard, and it is evident from the rulings, that the expansion of the categories of children eligible to be considered under Jordan's principle did increase the number of people who may receive compensation under the compensation framework. But it's important to be clear that it's not a straight calculation. Not every First Nations child who becomes eligible for consideration is going to receive a compensation award or a full compensation award. And I say this for a few reasons. And you've heard this one yesterday from the Caring Society. Under the compensation framework, the children who are brought into eligibility in the First Nations child decision will not be eligible for special compensation under Section 53, Sub 3 of the Act for willful and reckless discrimination. And as the Caring Society explained, that's by virtue of the operation of Clause 4.2.5.3 of the compensation framework. There is a tribunal decision that comments on the rationale for that. That's 2021 CHRT 6 at paragraph 109. And that decision is another example of the dialogic framework at play. The parties, as they were working on the compensation framework, did have some issues that they needed to put back to the tribunal for clarification. This ruling is the result of one of those steps taken in the course of the proceedings, and there is some discussion there about that clause in the compensation framework. There is a second point to raise, though, which wasn't touched on yesterday, which is that while children and parents and caregiving grandparents who are brought into eligibility under the First Nations child decision won't get that compensation for willful and reckless conduct, they will be eligible for pain and suffering awards under Section 53(2)(e) of the Act, subject to some important parameters. So of course, they'll only be entitled to compensation if they experienced a denial, gap, or unreasonable delay with respect to an essential service. And this is probably the important part, and where that occurred in the time period from January 26, 2016 to November 2nd, 2017. So, and I'm just taking you to this so that you have the references as you think about the connections. This comes from clause 4.2.5.2 of the compensation framework. And as a reminder, that framework is in Canada's condensed book at volume 1, tab 4, and this clause is on page 265 of that condensed book. So again, there is a time frame, a more compressed time frame put around Jordan's principal compensation for this group. And it runs, as I said, from January 2016. And as a reminder, that's the date of the merits decision in this case. And it runs to November 2017. And as a reminder, that's the date where the tribunal found in the compensation decision that Canada had brought itself largely into compliance with its directions on Jordan's principle. So those are where those two dates come from. And just to point this much out, this is a much shorter eligibility timeframe than exists for First Nations children who are registered or eligible to be registered under the Indian Act. Their period of eligibility for Jordan's principle related compensation begins in 2007, if I'm remembering that right. I hope I am. It's an earlier date anyways. I think Mr. Taylor is nodding at me. I hope that means that I have that right. I don't have it right in front of me. But their period of eligibility really begins with the passage in the House of Commons of the motion with respect to Jordan's principle. So again, I just wanted to make sure it was clear for you how these periods of eligibility were set out in the compensation framework. And again, there is some discussion by the tribunal of the rationale for this in that same ruling, 2021 CHRT 6 at paragraphs 109 through 113. And I'll just maybe add one thing in case there are any questions in your mind about it. We say there is no inconsistency under the Human Rights Act in finding that these categories of children are eligible for pain and suffering awards under 53(2)(e) of the Act, but not for willful and reckless damages under section 53(3). And you heard about this from the Caring Society on the first day in respect of the compensation awards, but these two categories of remedies are doing different things within the structure of the Act. So these are statutory remedies which have unique statutory purposes, and they do different things. And the pain and suffering awards under section 53(2)(e) are really intended to focus on the impact of discriminatory events on a victim. And the intention of the respondent is irrelevant to the award of pain and suffering. And so this is what distinguishes the two categories. The special compensation, in order to be awarded, does require some element of either intentional conduct or reckless conduct on the part of the respondent. So there's no conceptual inconsistency in receiving one but not the other. And in fact, if you look across the tribunal's body of case law, you'll find many examples of cases where pain and suffering awards are made, but where the threshold for special compensation has not been reached. You will, of course, also find many where both are met and for good reason. But there's nothing inherently inconsistent about being eligible for pain and suffering, but not special compensation. So with that, I think I'll move on to my seventh point, which relates to arguments around burdens on First Nations And the rest of my submissions, I'll probably be pretty brief because I'll mostly be adopting arguments made by others. But Canada has, of course, said that the community recognition category under the First Nations Child Decision unreasonably imposes obligations on non-party First Nations. And you have heard from Chiefs of Ontario that potential burdens on First Nations were top of mind for it and others at the hearing that led to the First Nations Child Decision. And they have told you very eloquently, in my view, yesterday, that they are satisfied that the resulting decisions, including the recognition procedures and the list of recoverable expenses that are attached to 2020 CHRT 36, do not impose any such burdens on First Nations. And instead, the tribunal's orders are purely voluntary, setting out procedures that First Nations may choose but are not required to follow in respect of recognition of children for purposes of Jordan's Principle. So having heard arguments and read memorandums this week, it appears to us that the AFN, Chiefs of Ontario, and NAN are in unanimous agreement on this point, as is the Caring Society, and all support the reasonableness of the tribunal outcomes. So we agree with them in that regard and have nothing else to add on that point. Yeah, and maybe just in a similar vein, I'll just say this, another point with respect to consultation and consent. So Canada, of course, has suggested that the decisions are unreasonable because they were rendered without consulting with individual First Nations, or because they deal with matters on which different First Nations might hold different views. And again, Chiefs of Ontario spoke to this point very eloquently yesterday. Its submissions were adopted by NAN. They're consistent, in our view, with those of the AFN and the Caring Society. And again, we agree and have nothing else to add on that point. And Justice, I think actually, I blurred a few things together, and I think that was my last point. I don't know if it was what I said I was going to start with, but hopefully it was close. But that does bring me to the end of our submissions. Maybe I'll just say this, again, to make sure it's clear, the Commission's view is that the Tribunal's First Nations child decisions are reasonable when assessed in the broader context of this case and against the constraints that may exist. They are consistent with the purposes and wording of the Human Rights Act. And so we say that they ought to be upheld. You have our submissions already on what judicial review remedies might look like if you did find some aspect of the decisions to be unreasonable. So I won't repeat those here. And maybe just a closing remark to follow up on the Assembly of First Nations comment this morning about the high degree of interest, I think, in reaching resolutions with respect to these issues. I just wanted to point out for your information, basically a clause in the compensation framework that speaks about timing, just so that it's in your mind and maybe give some context for the AFN's remark. So in the compensation framework, you'll see clause 7 deals with a timeline for the claims process under the compensation framework. And section 7.1 of that framework says that the implementation date for the rollout, essentially the start of the rollout of compensation, will follow the date on which the tribunal's orders become final. And the compensation framework says that they'll be final once there are no judicial reviews or appeals pending. So, I think for all sorts of good reasons, the compensation framework is written in a way that won't start to see work unfold until there's some certainty around the tribunal's rulings. And of course, your decisions will be eagerly awaited by all of us, and I think by people all across the country, to give us some clarity about where we go from here. So thank you for your time, both earlier this week and today. And those are my submissions, subject to any questions you may have.
Thank you, Mr. Smith. I've got one question. You've kind of dealt with it, but I just want to have it a little bit, flushed out, I guess, just for the purposes of reflection. Once we conclude, you've talked about the nature of the claim as framed in response to some arguments of your friend. So it's, I guess it's a little bit of a long-winded question statement, but we can clarify if you need a more specific question. So I just want to understand the clearly. I think I do, but I just want to be crystal clear. So if a complainant brings forth a complaint of discrimination based on circumstances at the time of the complaint, and over the course of proceedings, it's like an onion. Different things become more apparent, or there's more awareness of I guess the scope, I guess, of the discrimination. Just in terms of the tribunal's approach, are they? You've kind of touched on this, but I think you're suggesting that it's and other parties are suggesting that it would be not useful to send every matter, every one of those discoveries or awareness, leading to the continuance or furtherance of the discrimination. It would be unfair to send those back for another complaint, again, as you outlined the process. The statement of particulars, all the pleadings, the actual hearing, and then therefore there might be other compliance issues. So is it, again, so your understanding or your submission with respect to the remedial authority of the tribunal is that they can, as more things become aware, deal with them because of the initial complaint of discrimination, if it's related. So I'm just looking at the ties.
Yeah.
I think the ties are, I guess I'm questioning, are the ties relevant, or how relevant are the ties, or how close do the ties have to be to the initial complaint of discrimination? Is that?
Yeah, your question's very clear. It's a question that comes up frequently, so I'm happy to speak to it as best I can. And of course, this is our views as the Canadian Human Rights Commission, and we are a regular litigant before the tribunal, but we are just a party. But I'm happy to tell you what we think is the right approach and what we think that the case law calls for and what we think is consistent with the intention of Parliament as expressed in the Act. So you're right, it is not at all unusual for complaints to be filed, for them to start winding their way through the Commission's assessment process, which of course takes some time, for them then to be referred to the tribunal, and then for new issues, new perspectives, new evidence to be discovered at the tribunal that may lead to a reframing or reshaping or drawing different boundaries around the scope of the tribunal's inquiry. So that's not unusual at all. And let me tell you about maybe the most mundane or routine circumstances where we see this at the tribunal, just to give you an example. Take an employment-related case. Someone files a case saying they've been experiencing discriminatory impacts at work. And they may file a complaint, and maybe it will say, my needs are not being accommodated, my disability-related needs are not being accommodated at work. They file a complaint focused on that. It gets sent to the tribunal. Shortly after it's sent to the tribunal, the person is fired from their job. And the Human Rights Act contains a section saying, well, it can be a discriminatory practice to retaliate against someone who has filed a complaint for having done so. So now parties are at the tribunal. They've got an ongoing case. The complaint is framed with a focus on accommodation of disability-related needs at work. But the complainant is saying, well, I just got fired. Do I have to go file a new complaint, start at the beginning of the Commission's assessment process in order to have that issue addressed? Or can I just have the tribunal make a ruling that says, no, I can raise this new issue which arose or was discovered after I filed my complaint in the context of this original proceeding. And there's a lot of case law at the tribunal that says, no, we are not going to send people back to the beginning of the administrative process every time a new development occurs. We can exercise the power that we've talked about earlier this week to effectively grant leave to parties to amend the scope of the inquiry to deal with subject matter that may not have been highlighted in the complaint or even in a pleading, but which still has some nexus to the subject matter of the original complaint. And the tribunal's case law there is quite broad. So it basically will use language along the lines that I've just described. Issues that arise post-filing of complaint and post-referral may still be brought before the tribunal and addressed as long as they have a sufficient connection to the subject matter of the original complaint. The tribunal in our submission has left itself a lot of room for maneuver there. But there will from time to time be a case where someone wants to raise a new issue that is so far removed from what the original complaint was about that the tribunal will say, no, that this one is one step too far. You would be better served, and Parliament, in our view, intended for you to bring this substantially new complaint back to the Commission to go through the entirety of that administrative process under the Act. So, when I think about that in the context of this case, my first thought is that everything that we've been talking about has that sufficient nexus to the original subject matter of the complaint. And when we look back at the complaint as it was originally framed, we do see the reference in there to Jordan's principle. And we do see, of course, the allegations of discrimination in the delivery of child and family services. But we also see that reference to Jordan's principle. But then, as you also heard from me earlier in the week, once you're at the tribunal, it's the pleadings that really set the initial scope. There again, we saw that Jordan's principle was mentioned, and it was mentioned in broad terms that did not limit things by virtue of on reserve status versus off reserve status, or by reference to registration under the Indian Act. So we can see from early stages in our submission that Jordan's principle was part of the case. And then, as we progressed throughout the hearing, the tribunal engaged with the issues and made findings that were not challenged. So we see this kind of development of the case, but always in ways that link back to the original subject matter. Yeah, maybe I'll stop there. I don't know, Justice Fellows, is that a responsive answer for you? I hope that I've covered it off.
Yes, yes, you have. I just wanted to place it in the proper context and again, just as you clarified.
And sorry, maybe I will say one more thing, which is probably obvious, but overlying all this, of course, is the tribunal's obligation in all cases to afford procedural fairness to the parties. So, the Act requires it, principles of administrative law require it. So, at all stages, parties ought to have notice of the issues that the tribunal has before it and an opportunity to make submissions. So that's a constant. But again, in our view, as you track the evolution of this case over time, it's our view that that requirement has been met throughout. So in each circumstance, in our view, Canada has had the opportunity to engage with the parties' arguments with respect to the scope of Jordan's principle. It's had an opportunity to provide its arguments in response. And then the tribunal has written extensive and lengthy reasons that engaged with the arguments. So it's also our submission that if you look at the pattern of the case over time, you'll see that that procedural fairness obligation has been met, and it's been met in ways that have that sufficient connection to the complaint as initially framed.
Thank you, Mr. Smith. I don't have any more questions. So I think it would be now would be an opportune time for a short break. We can reconvene at 10 after 11, and we'll hear the reply submissions of the Attorney General of Canada, and we'll see you in a few moments.
Court is now resumed. Thank you.
Hello again, everyone. As mentioned, we're nearing the conclusion of our proceeding on the eligibility case decision, the judicial review of that decision. So we're going to hear from the Attorney General of Canada and Mr. Frater in reply to the submissions. Mr. Frater.
Yes, thank you, Justice. And just before I begin, and I should have done this before the break, I was wondering whether the elder is still present. And I say that because I expect to be roughly 40 to 45 minutes. So I think we can safely finish before the lunch break today if the elder is prepared to close the proceedings.
The registrar, I believe, had reached out. Maybe we can hear an update.
I can confirm, Counsel and Justice Favell, Elder Sakani knows, and I have informed him that we will close before our lunch break.
Thank you.
Welcome.
Mr. Frater, we will begin hearing from you.
Thank you. Justice, I want to begin my submissions by admitting to two errors in my submissions of yesterday. As my friend for the Caring Society has pointed out, when I was speaking of the SJ case, I should have qualified my submissions on the facts of the case by pointing out that the tribunal essentially accepted the position of the Caring Society on those facts, which differed in some respects from our own. Second, counsel was quite right that the compensation framework, which was accepted by the tribunal, did not award willful and reckless compensation to First Nations children who were recognized by their community for the purpose of obtaining Jordan's principal services, or had one parent eligible for status or their caregivers. Compensation was awarded to this class for pain and suffering, a matter I will return to in a few minutes. I apologize to my friends in the court for that error. I should have remembered that since I was at the table negotiating that agreement. Justice, in response to my friends' collective submissions generally, I would expect that at this point in the proceedings, you may be somewhat in a state of puzzlement. What you heard from our side yesterday and what you heard from my friends opposing yesterday and today are in some respects like two ships passing in the night. For my friends, the issue on this application raises critical issues like First Nations' ability to define who is a member of their community, and issues about the application of international law, application of the quasi-constitutional nature of the CHRA, and Section 35 of the Constitution Act. For Canada, the issue comes down to something much simpler. Did the tribunal have before it the evidence to make the order it did, bearing in mind the complaint that was before it? Now, for counsel to differ on such issues is not unusual. It's a common problem in litigation. Parties frequently cannot agree on the dispositive issue in a case. In our view, our friends' submissions either avoid or obfuscate the issue of whether the tribunal had a sufficient evidentiary basis to make the orders it did. Now, I submit we can at least agree on this general statement. Pursuant to the tribunal's rulings on Jordan's principle, Canada has a legal obligation to provide supports and services for First Nations children, whether on or off reserve, to ensure that there are no gaps in services. That follows from the tribunal's definition in 2017 CHRT 14, which you have heard much about. Now, there's more to it than that, I acknowledge, but that is probably sufficient for the argument before you. So the definitional issue at the heart of this case is, who are the children who can apply? Now here, I think we agree with the Caring Society that it is something of a threshold issue. Who gets to apply? Counsel for Amnesty International, with respect, spoke to this issue in respect of UNDRIP, but in our submission, UNDRIP doesn't help us with that issue because it's a who issue. And UNDRIP, as my friend pointed out this morning, specifically does not deal with questions of who is Indigenous. Apart from our agreement on the issue of who gets to, that the issue is who gets to apply, our positions begin to diverge. Now, my friends take the position that the appropriate way to look at the issue is through a lens of Canada's previous failures to promulgate a definition that complied with the merits decision of 2016. And in our defense, I would say that the merits decision provided precious little guidance, contrary to what has been submitted to you. Counsel for the AFN pointed you to 3 paragraphs, but we would say that the clearest statement in that judgment perhaps was paragraph 351. So let me take you to these paragraphs because it sets the stage in our submission for consideration of the issue before you. So where I'm looking is in the Caring Society's compendium at volume 1 of 2, the decisions brief, and tab 1. You have the entire decision there, and I'm going to take you to paragraph 351. So we're talking about 2016 CHRT 2, and paragraph 351 is the first one that I want to take you to. Justice, do you have it now?
I do.
Okay, paragraph 351 goes like this. Jordan's principle is a child-first principle and provides that where a government service is available to all other children and a jurisdictional dispute arises between Canada and a province territory or between departments in the same government regarding services to a First Nations child, the government department at first contact pays for the service and can seek reimbursement from the other government department after the child has received the service. It is meant to prevent First Nations children from being denied essential public services or experiencing delays in receiving them. Now, the AFN, in their submissions, said that there were 3 other relevant paragraphs, and if my notes are correct, I believe what counsel said were that they were paragraphs 381, 388, and 451. So let's go to paragraph 381. What that one says that is, in the panel's view, it is Health Canada's and AANDC's narrow interpretation of Jordan's principle that results in there being no cases meeting the criteria for Jordan's principle. This interpretation does not cover the extent to which jurisdictional gaps may occur in the provision of many federal services that support the health, safety, and well-being of First Nations children and families. Such an approach defeats the purpose of Jordan's principle and results in service gaps, delays, and denials for First Nations children on reserve. Coordination amongst all federal departments and programs, especially AANDC and Health Canada programs, would help avoid these gaps in services to First Nations children in need. 388, I don't plan to read to you, but if you turn it up, the point I'm going to make about each of the three paragraphs that my friends have pointed to is that none of them provide any significant guidance in determining who is a First Nations child for the purposes of Jordan's principle eligibility. The final one, though, that I want to refer to you, and Council referred to it again this morning, is paragraph 481. And let's just go to that one. It was read to you at least in part this morning. But it's an important one because that paragraph reemerges in the compensation decision. So at 481, what the tribunal said is, the panel is generally supportive of the request for immediate relief and the methodologies for reforming the provision of child and family services to First Nations living on reserve, but also recognizes the need for balance espoused by AA and DC. AA and DC is ordered to cease its discriminatory practices and reform the FNCFS program and 1965 agreement to reflect the findings in this decision. AA and DC is also ordered to cease applying its narrow definition of Jordan's principle and to take measures to immediately implement the full meaning and scope of Jordan's principle. So that phrase, the full meaning and scope of Jordan's principle, reemerged in the compensation decision at paragraph 5. So with respect, and I'm sure you'll review them again, but none of those paragraphs help in any way in deciding who is a First Nations child for the purposes of Jordan's principle eligibility. Paragraph 351 sounds like the parliamentary resolution from 2007. The other paragraphs just stress the importance of First Nations children getting their needs met. Telling Canada to implement the full meaning and scope is only helpful if you know who the definition encompasses. Now, you also heard from my friends about the importance of the principles of best interests of the child and substantive equality. But as important as those principles are, they only help us with the question of what the children should receive after they've been approved or when they're being considered for approval. Canada's failure in the 2016 to 2017 period was in trying to analyze who the definition encompasses question by seeking to move beyond intergovernmental disputes, but not far enough for the tribunal. But we say, in fairness, again, there was not a lot of guidance on the definition issue from the tribunal, as they later acknowledged in the First Nations child judgment. The key point of difference between us, in our view, is that we say that the relevant context for deciding the who question is the complaint, the particulars, and the evidence. Because the only sensible answer that can be given to the who question is the children who are subject to the discrimination described in the complaint, the particulars, and the evidence. Now, I'm not going to dwell on the complaint and particulars because I've been there before this week, and the references to Jordan's principle are very few and do not help us, contrary to what you heard from the Commission a few moments ago. Both the complaint and the particulars make repeated references to discrimination against registered First Nations individuals on reserve. They were the subject of the discrimination experienced as put forward by the complainants. So it has to come down to the evidence in our view. Did the evidence support the two orders that were made? Now let's just have a look at the orders that were made. So if we can go back now to our compendium at volume 2, where we've got tab 3 of volume 2, where we have the decision that is the subject of this judicial review. And if you can turn up paragraph 229, and you've heard counsel refer to these before, but it's important at the end of these proceedings, I think, to come back to the actual orders that are the subject of the review. So what you see at 229 is, pursuant to section 53 sub 2 of the Act, the AFN, the Caring Society, the Commission, the COO, the NAN, and Canada are ordered, 1, to consult in order to generate potential eligibility criteria for First Nations children under Jordan's principle, and in considering the panel's previous orders and clarifications explained above, and 2, to establish a mechanism to identify citizens and or members of First Nations that is timely, effective, and considers the implementation concerns raised by all parties. In considering the identification mechanism, discussions should also include the need for First Nations to receive additional funds to respond, and in some cases, build capacity to answer Canada's identification requests for First Nations children. The mechanism should also include provisions for additional and sustainable funding to account for the children who will now be included under Jordan's principle. So that is one of the orders. The second is at paragraph 272. The order there is that the panel, pursuant to section 53 sub 2 of the Act, orders the same parties to include as part of their consultations for the order in section 1, First Nations children who do not have Indian Act status and who are not eligible for Indian Act status, but have a parent or guardian with or who is eligible for Indian Act status. Okay, so the first order is what led to the other decision under judicial review, which is 2020 CHRT 34, which fleshes out the community recognition process. Now, why is, as I said to you, we say evidence matters here. Why is the evidence important? Well, in my submissions yesterday, you raised with me the fact that the tribunal showed some restraint in not extending the definition of First Nations child beyond what it did in these two orders, despite a request to do so. And let's go back to what they did there, because I think that's important too. We're talking about paragraph 279. So what the tribunal said in 279 and 280 is that despite the lack of evidence referred to and relied upon by the parties in support of this issue 3 request, the panel extensively reviewed the evidence before it. In reviewing the record, the panel reviewed the parties' statements of particulars, the parties' final arguments, the evidence the parties relied on in their arguments, and the evidence as part of the interim motion. This being said, the panel finds that First Nations children residing off reserve who have lost connection to their First Nations communities for other reasons than the discrimination found in this case fall outside of the claim before it. Claim was not focused on this at all until the 2019 motion, and sufficient evidence has not been presented to support such a finding. As the panel previously said, the Supreme Court of Canada stated in Moore that the remedy must flow from the claim. So we say that was entirely the appropriate approach to that issue, and should have been taken with respect to the other two categories as well. The particulars, in our view, do not support the extension to this third group, but neither do they support the extension to the other two groups that the tribunal did find it was discriminatory for Canada not to extend eligibility to. So the question is, the particulars don't do it, does the evidence? Now, Counsel for the Caring Society referred you to the evidence of Mr. Sonny Perron, who was an assistant deputy minister at the time. He did not take you to that evidence. But in my submission, I think we need to go there. His evidence was referred to again this morning. We say that the evidence of Mr. Perron was critical on this issue. This is the evidence that was heard before the tribunal according to our reporting requirements that had been imposed by the tribunal. And it was in May of 2018. So where you'll find that in the record, just so you have it, is tab number 208 in the shared drive under compliance affidavits and responses following 2017 CHRT 14. And what I'm dealing with is Counsel for the Caring Society's cross-examination of Sonny Perron. So I'm going to start on page 23 at line 17. And before I do this, I should say to you, in fairness to my friends, whenever counsel starts reading snippets of a cross-examination to the court, as I'm about to do, it's a sign that the court should review the entire cross-examination, because as counsel will all tell you, cross-examination is cumulative, and in fairness, you should read the whole thing. But a lot of it in our submission is not particularly relevant, but there are some key passages that are relevant. So if you have that up, and we've tried to put it up on the screen for you, I'm at page 23, line 17. So this is Counsel for the Caring Society asking the question. But what we're trying to clarify is, because in reading this, First Nations children living on reserve, at least, it's not evident to me on the face of that wording that we're talking about children with Indian Act status or who are eligible for Indian Act status. And so just what I'm asking is, at the time, in July 2016, was it the case that having registration or eligibility for registration under the Indian Act was a program criteria for Jordan's principle? Pause to note that it isn't a program. The answer is yes, it was. Question, yes, it was. Now, in looking at tab 3, and this is the May 2016 decision. So this is paragraph 33. So this says, the panel orders INAC to immediately consider Jordan's principle as including all jurisdictional disputes. This includes disputes between federal government departments and involving all First Nations children, not only those children with multiple disabilities. So just to confirm, the wording here matches all First Nations children. We're speaking of the same thing, but the tribunal hasn't made anything about Indian Act status in this order. Answer, no, I would agree with you. It's not mentioned. Our interpretation, however, and this is the way most federal programs have been working, and the division of responsibility with provinces and territories, is that when we talk about serving nations, it's First Nations with status. inaudible to have status. If you look at the division of responsibility and when there is provincial program that is eligible for children, for example, and they exclude First Nations from it, they exclude First Nations with status. The status is making a great difference in terms of policy application in general. So, question, well, I'll answer. Usually those who self-identify as First Nation will not encounter challenges to access normative programs anywhere in the country where they are not excluded unless they have status. So in that passage, what we find there is that Mr. Perron is talking about which First Nations children are experiencing discrimination. It is those with status, which certainly justifies extending Jordan's principle to status First Nations children wherever they reside, on or off reserve. Second thing he says is that those without status who self-identify do not usually suffer the discrimination at issue. Let's go over now to page 27. And we're dealing entirely with the same counsel for the Caring Society. So the question is, so speaking to your experience then, which would have been Health Canada's Health Canada at this time is reading paragraph 33 and is reporting back to the tribunal in the May compliance report, and then is stating in its news release, it's echoing the words First Nations children, but it is reading that as in fact being children with Indian status. Answer, exactly, or entitled to be registered. Question, or entitled to be registered. Now, that's not something Canada ever explained to the parties. That's what it meant. Answer, I would say in our interaction, and I had many with partners, when it comes to leadership, most of the time they understood clearly that what we were talking about is community member recognized with status. If we go to page 31, what you'll see on paragraph 31 or page 31, and I'm not going to read all of this to you because if you read it, what you'll see is that the government was actually approving cases in urgent situations where status could not be determined. And you get some more of that at pages 32 and 33 on the fact that some in cases of uncertainty, there was coverage or an attempt to see if they could be covered in some other way. And finally, let's go to page 34. And there's a long question, which I won't read to you, but the answer that's given on page 36 is, the wage ordinance principle has been implemented until now, and this is what I mentioned before, is for registered children that either registered or entitled to be registered. We are doing an analysis of the situation for the non-status situation, and we have kept a number of cases pending. We are in relationship with the family. I think there is around 50 cases across the country right now that have been brought to our attention to see how we can support that. Some of the parties have brought to our attention some ways we could deal with this. One of the parties, for example, suggested that if a family is recognized by the band as a community member, we should treat them like First Nations with status. So we are doing an analysis of these situations and see how best to assess access going forward. And again, I say, it's important that you read the entirety of counsel's cross-examination. But here's what I ask you to take away from this. So although there is mention by my friend of the fact that the tribunal did not say anything about the Indian Act, the evidence from Mr. Perrone was that the children experiencing discrimination are those who have status, whether on or off reserve. Could also have included non-status on reserve, as Dr. Gideon's affidavit later described. But Justice, what you see in Mr. Perrone's testimony on cross-examination, I suggest, is not so much an attempt to slavishly apply the Indian Act for the sake of applying the Indian Act, but a rational attempt at approaching the who question purposively. Who is a First Nations child for the purpose of Jordan's principle? The children who are suffering discrimination. And those children, based on Mr. Perrone's interactions with First Nations, were status children, on and off reserve. Now, we are no further ahead on the who is suffering discrimination question if we simply accept my friend's arguments that First Nations should decide who is a member of their community for Jordan's principle purposes. Because if you want to approach this question purposively, and I suggest that is an appropriate way of doing it, and answer the who question in relation to discrimination, you have to ask, is there evidence in the record that shows which children were experiencing the discrimination that Jordan's principle is meant to remedy? Who experienced the gaps in services? And with respect, my friends simply do not point to any. Counsel for the Congress this morning said he would address this question directly. And the only actual evidence that he pointed to was the evidence in respect of SJ. My friend's case at the very highest is that First Nations should decide who is a member of their nation, or perhaps more accurately, that First Nations should be the ultimate arbiter of these questions. That is a critical principle that may be very important to reconciliation, but it does not necessarily assist us in identifying who is experiencing discrimination. And our concern, the narrow one that brings us before this court, is whether the tribunal should be making that decision on this complaint as framed and on this record as they found it. Ignore the question of whether the Indian Act should be determinative, even if you accept that First Nations should decide the question. As Canada, as my friends have pointed out, as Canada now accepts, did the tribunal have any basis to make the determination that Canada's definition was insufficient to avoid the discrimination complained of? And did they have any evidence to support the proposition that there was another group who experienced pain and suffering and should be compensated? My friends frame the dispositive issue for you on this application as who should decide who is eligible for Jordan's principle. They say the answer is clear. First Nations should decide. We, on the other hand, say that the dispositive question is who is eligible for Jordan's principle for the purposes of the tribunal's remedy in this complaint? And the answer to that must be, even if you were to accept my friend's question and answer, the First Nations children identified by the complaint, the particulars, and the evidence that were experiencing discrimination. Those are the victims that the tribunal can provide a remedy to under the Act. And with respect, there was no justification for holding that non-status, off-reserve children were within the terms of the complaint or experiencing discrimination, and no evidence to form the basis of an award of compensation for pain and suffering. Their own witness, Dr. Trocme, as I read to you yesterday, said the issue required study. Now, to the assertion by counsel for the Chiefs of Ontario that a remedy must be provided where it is sought, we say that it must be proven, as the tribunal stated in its response to the third question. And that is what they should have done with respect to the other two questions. To the Chief's assertion that what Canada is asking for is cookie cutter solutions, we say that creative remedies can be given, but only where they are justified by the complaint and the evidence. This is a simple case in our submission of overreach by the tribunal. Now, on the second question, relating to whether those who are off reserve and do not have status as a result of the Indian Act cutoff suffer the discrimination complained of, there was evidence of, and it was the evidence of SJ. But the issue was essentially dealt with by the tribunal as a question of pure law. Is Section 6 sub 2 of the Indian Act good law or not? Counsel for the Caring Society said that there has been a lot of harsh criticism of Section 6.2 in the case law. We agree, yes, and constitutional challenges brought to it, of which this case is not one. The tribunal can't just borrow constitutional law without a challenge. And it was not a question raised by the complaint or the particulars or an amendment, as counsel for the commission suggests, or for which evidence was presented apart from the case of SJ. And in our submission, too important to be dealt with in a motion such as this. My friends have pointed to Canada's statements. Canada has indicated that it would consult further on this issue. Now, let me respond to just a few other points raised by counsel. Counsel for the Caring Society says that because Canada has announced that it is going to apply the community recognition process, regardless of the result in this case, this application is an abusive process. There is no basis in law for that submission. We are here to challenge the tribunal's overreach of their authority, not just on that issue, but on the second one, the Section 6.2 issue as well. There is nothing inconsistent with accepting the result while challenging the authority of the tribunal to order it. Vavilov tells us that the reasoning process and the outcome have to be reasonable. We say that the tribunal had no business making that decision, which also impacts compensation, and that is why we are here. But let's be clear about this. The effect of Canada's decision to accept my friend's position that First Nations, not Canada, should be the ultimate gatekeeper on access to Jordan's principle is a decision that is open to Canada to make. Whether non-status, off-reserve children face the same discrimination as children with status, it may be more important as a matter of reconciliation to simply ensure that First Nations have the final word as to who can apply for Jordan's principal supports and services. And it is also an answer, I would say, to counsel for the chief's concerns that modern treaties and Bill C-92 both are directed at moving towards First Nations having plenary jurisdiction over child welfare matters, including making First Nations the ultimate decision maker on matters such as access to Jordan's Principle. Allowing First Nations to have that gatekeeper role thus promotes consistency and promotes the First Nations' own authority. Counsel for the AFN in his submissions said in essence that the tribunal did everyone a favor by deciding this issue. Commission took that position as well. We say convenience does not give the tribunal a mandate to make policy decisions. They have a limited statutory mandate. It depends on receiving evidence of discrimination, and they have to stay within their lane, to borrow my friend's term. They are not entitled to any deference on decisions they ought not have made. Now, my last point is in response to the Commission's answer to your question at the close of the submissions about the evolution of this complaint. And in answer to that question, what my friend pointed to was the possibility of amendment, that an amendment may be sought. As I said the other day, no amendment was sought. Second, I remind you, because the Commission said, well, Jordan's Principle was mentioned in the complaint in particulars. The mention of Jordan's Principle in the complaint and the particulars is nothing like what the tribunal did here. Third, we say there's no case law to support changing the case at the remedial stage. And finally, while my friend talked about nexus, it strains the concept of nexus beyond any reasonable bounds to talk about a nexus between where we started in this case and where we ended up. Finally, Justice, we say we are here because the tribunal in this case, as in the compensation decision, simply goes too far. Federal Courts Act gives you the responsibility of ensuring administrative decision makers stay within their lane. We ask you to allow the application because this tribunal is overreaching its authority. Justice, this has been a long week, but I would like to end where I began and say that Canada is committed to compensation and committed to continued reform of its approach to child welfare. There have been respectful disagreements this week about certain issues, but we believe there is much common ground on the overall goal of ensuring that First Nations children are able to thrive. Subject to any questions you might have, Justice, those are my reply submissions.
Thank you, Mr. Frater. I don't have any question. I was going to pose the question that I posed to the Canadian Human Rights Commission, but you've addressed that in your submissions, and I've reviewed all of the submissions this week, and I'll take those with me as well when I deliberate. So thank you. I don't have any more questions for you.
Your Honor, and I asked this with great reluctance given the length of the week, but if I might have leave for just a very brief point of reply with respect to Mr. Perron's cross-examination.
Very briefly, very briefly.
And that's just to state that the Mr. Perron's evidence says what it says, The questions there were eliciting what the current state of the evidence was with respect to Indian Act status as an eligibility criterion. And so Mr. Fraders encouraged you to review the whole transcript. I'd also just like to add an encouragement to look at Ms. Buckland's transcript, which is tab 183 from February 2017. That's the complement to the point that was being made in cross-examination there. Thank you.
Thank you. I can assure all counsel that whenever something has been referred to me to review, I will review. So that's, which gets to, I guess, the point raised by Mr. Wetke in terms of the expediency and expedited nature or the request for a ruling. As you are all probably aware, I will be reserving my decision and taking some time to write it out. So there is no decision today. And I'm very well aware of how important this is to children throughout First Nations children throughout this country. So and how important it is to all of you who are advocating your respective interests. So I will undertake to do that. I don't have a guarantee as to when that will happen, but I am cognizant of the AFN's request for an expedited decision. So thank you all again for your submissions. You've certainly given me a lot to consider, and I will take it all under advisement bit by bit as I go through my notes and the recording. So thank you again. That brings us to the conclusion, and I'll turn it over to Elder Sekani to properly close this. And so if Elder Sekani is available, the floor is yours.
Miigwech. Kaya Quayas po iwitutin naman. Kapitime uma Tabasco. Thank you, Your Honor, for coming to speak and for wanting to take that time to come up with a judgment of these proceedings. Kitehuche, Kiyame. I see that you spoke from your heart, because if you render the decision right now, it's not respect. It wouldn't be respectful, and you have more integrity than doing that. Mona tabwe gagabehem oma the I won't really close this session because it's not over. However, if a decision is made, and there will be further discussions, I'm sure, then I will close it then, because it's going to be a new approach. Caring Society, AFN, Chiefs of Ontario, Anaganista Human Rights, Mogamaganista, Miss Webago, Kapechiami, Chikuta. I would like to sincerely thank the Caring Society, AFN, Chiefs of Ontario, NAN, and also the folks that spoke from the Western side, the human rights, and the rest that I've not mentioned. And not necessarily in that order when I talk about my people. Kinoa, Kayamiak, for those people that spoke on behalf of us, you did well. You spoke from the heart. Bogamaganesta. Anige Misle Bogagabitizic. Ganuchitaya from Georgian Principal Gatonova, Miigwech, and all those people that work in the background for the Jordan's principle, I want to thank you as well. No taono, Kishamanto, Miigwech nito, Anoshako, Jordan River Anderson, Nagasko Kimatiso. And I also want to thank my great creator for Jordan River Anderson. He lived a very short life. His spirit is still here. Without him, we wouldn't be discussing this. Miss Wibago, Anna Awashish, Pinuchita. He touched on everything that's happening within this country. Your Honor, we usually close by, I want to tell you a story. And I hope the person from Justice Canada is listening. He talks about evidence. He talks a nice talk. But he's here primarily to destroy the Aboriginal people, the Aboriginal children. That's his mandate. It's a thing called, and I'll be honest, genocide. That's what it is. He speaks about inclusivity. He speaks about all that. Real nice talk. Does the moon walk? But the fact is, we wouldn't be here if the past governments had dealt with this in a proper, respectful way using the 7 teachings. We wouldn't be here. Now he's bringing up stuff that should have been dealt with. It should not come to this session. Should have. But now they're saying, rip the agreement up, to try to rip it up and start all over. Well, we have moved somewhat, so why start over? Any questions? The Aboriginal people wanting some control. I support that control because we can do it. We have enough people now that can do this. We can do a better job if they allow us. He talks about the compensation. What is that in comparison for the billions and billions they took from our ancestral lands and not return anything really? He talks about spending billions on us. Well, what about those billions you took? It's minute to what you took. My story is this. As a child, I was taken by Children's Aid behind my mother's back, and my dad was killed by a non-native person, and that non-native person was never penalized, didn't have any legal consequences. He didn't even pay for that. And as the police, I remember as a kid, I was about 4 or 5, when the police came into my home, we had a 2-bedroom home with 13 people living in it. An older guy came, his hair is white and older. He said, "What happened here?" And I will never forget that. One of the police officers said, "Oh, it's just another Indian that got killed." Well, that Indian was my dad. And they went to court without including my mom, my awesome mom. And they took us away. Put us in a police car, Children's Aid car, and they took us away behind our back. And I ended up in foster home. That's the justice we got because we were suffering at home. My mom was suffering. I'll challenge any of you. If your partner was taken in front of you, how would you react? You would go in deep depression, and that's what happened to my mom. And the fact that we were taken without her knowledge is shameful, heartless. Then put on foster home, then it got worse. We were sent to a residential school. In fact, two. The first one my siblings were sent to was a Anglican residential school. About a month later, we were kicked out of there because we were Catholic. We didn't belong there, they told us. You need to go to a Catholic residential school, and by going there, you're going to go to hell, whatever that meant. So I went there. And I suffered every form of abuse that you can think of. Sexual abuse in my home, my own home. My beautiful mother was raped. I seen it as a child, or perhaps 5 years old. I seen it. Now tell me if that's a normal way for a child to grow up. That's forever etched in my heart, but it's healed now. Then I go to the school and that happens to me. And I came out of there enraged because what they did to the little boy who couldn't defend himself. And the fact is, all that, this Jordan principle, all this happened way before 2007. Here I am, 67 years old, and at that time I was about 4 or 5. Miigwech Ntana Mama. I want to thank my mother, my late mom, because she used the courts to get us back. Here's a lady that had no education to speak of, couldn't talk the language. She only had a grade 1 at a residential school, and she was there from 6 months to the age of 16 years old. She was trying to be a domestic person, clean up and all that stuff, no education. She used a young man in our community who graduated from grade 13 to get us back. She showed him all the papers and court papers, and the young man read and said, "You didn't sign anything." She said, "No." Then she had to go visit his parents because they were older than her to get permission for him to battle the court system. And thank God there was a sympathetic judge who saw the misjustice of this all. And he gave those people, heck, the lawyers, children's aides, the police, everybody, for ganging up on my mom. And my mom went out of her way to get us back. Took her years, but she did it. Along the way, I got another dad. And I'm proud of saying that. She found another man and he became my dad. How many people can say they had more than one dad? You know what? This dad was a white man. Boy, was I livid, because it was a white man that took my natural dad. Now this guy's going to come into my life. But thank God he did. As he told me, "You know what, Ed? I can't take the place of your dad. But your mom was a huge package deal. There were 13 of you. I couldn't tell her. I just want you and not the children." And he came at the right time. Then my mom healed. I don't think the Justice Canada rep can understand this, what we mean by holistic healing. Because my mom lived to be 85, 88 winters. And we had a good 50 years with her after we came home. I went through a lot of emotions listening to you folks, and I'm privileged that I was able to sit through all this, privileged and honored. You know, Canada APTN Jordan Principle. Those of you who are working for Jordan's Principle, because you work from your heart and you spoke from your heart. I'm glad that treaties were mentioned, because that's the sacredness of these treaties. It's a sacredness for life. in many lives. I'm really disappointed in Justice Canada, Prime Minister Trudeau, who came in with so much fanfare when he was elected, nation to nation. It never happened. It will never happen. And yet they dare wear the orange ribbon. As a former residential school, what I witnessed is insulting. I request you take that ribbon off because it's a sacred symbol to us. And you tell that Trudeau, that leader, do the same thing. Enough of your talking. You're shallow. When I look at your eyes, I don't see a spirit to this government rep of Justice Canada. I don't see spirit. I see nothing. And then when the judge asks you questions, you get all shifty. And you have to look at your papers. I have to come up with a proper answer to fit this judicial system. Whereas and I notice all the people that spoke on behalf of my children, our children, are all young people. Not Justice Canada rep. How did Prime Minister Harper put it? Oh, you're from the old stock, Canadian. You're old stock. And that's where the problem began. Because one time they were dominant, now you're starting to see it's not working anymore. When I went to residential school, the biggest mistake they made with me, besides all the other stuff, was to educate me. Because of the fact that of this boy, this wonderful boy I've never had the honor of meeting, has brought this forward. You even use the word friend in a very shallow manner. Why don't you be honest about it? The people speaking on behalf of the Aboriginal children are not your friends. You made them adversaries. You can't go back and say, let's start over. Let's get some new people. You can't do that. It's already been rendered. It's too shallow. It's just the same thing like you try to treat our treaties. So I'm fortunate because I can go in the bush here because I had to. I have a wife that I've been with for 45 years. I think it's 40. I better get that right because she'll know that I could speak to how I felt. I have two sons. One is working nearly completion of his master's, and the other one is going to human resource management. I made sure the residential school never touched them. I made sure that the onuses belong to me, that I'm going to take care of it. I have two beautiful grandchildren, and I'm going to make sure that it never touches them. Racism and all that nonsense that you people promote. The government promotes that in every facet of their dealings, racism. And this is what this is. And it's about finances. This country is coming to its crossroads where it has to face up to the fact that they made some terrible, terrible, horrific mistakes and left a legacy of holistic hardship to my people. You're going to have to deal with that. And the fact is, with that, you're going to have to answer. Find a truth answer, even with what we're talking about today for the last week. Thank you, Justice, but I'll end this with one more story, a brief one. I had one of my chiefs who was a chief here for about 40 years. And this is just an analogy. So he decided, he was watching TV one day and he sees these big cruise ships. So he told his wife, how about we go on a cruise? And he told her they have all kinds of stuff here, hotel, it's like a hotel, he goes. Then his wife tells him, why don't you go by yourself? Because if I want to go to a hotel, I want to stay on a hotel that's on the land, not on the water. So off he went. Unfortunately, while the second day, they hit a big storm and the ship capsized. Everybody spilled over and everybody's racing to the lifeboat. So he found one, climbed in, but those lifeboats were made for 20 people. So there was 21. So that an English guy from England stands up and says, you know, I'm from England. We have the common law, we have royalty, we have values, we look at life with a stiffer upper lip, whatever that means. So to make sure that everybody is safe here, I sacrifice my life. So he jumps over. Of course, a guy from France cannot be outdone by the English. So he stands up. Oh, we have civil law in Canada. We brought civil law and all this stuff. And we're much more worthy of the English. Then the Canadian stands up and says, in our country, we have common law. We have civil law. We try to protect the language because of their distinctiveness, French and English. We develop a country, did all kinds of nice things. We're polite, we're kind, we're generous. So he gets up and says to make sure that we're well below the number and make this lifeboat extra safe, he picks up my old chiefs and he throws them overboard. That's how Canadians treated Aboriginal people. That's how Justice Canada wants to treat our children. Grab them, throw them overboard, and let them drown. So I will pray for you, Justice, because you have a tough job. I respect that you made that decision on your volition to become to where you are. I will pray that you find justice that's going to include everybody, even to our adversaries. And like listening to you and watching you, I really trust you have that ability. Me wetnetom, kapit jemia, ogamanesta, anagin no mojomak no gokomak, staku, kapit wichek, anatishka, kapit emian amichigan kevisha. I always thank my spiritual grannies and my grandpas. For each morning when I get up, I pray. I thank them for coming, helping here to join your wonderful folks. It's a privilege. It's an honor. Ogamaganesta, anage washasha. Wichehek. Bishamantu. Ogamaganesta, wichehek ogo. Kapitium, miserable, kapitium, teguta, to pass on, katonoa. I ask the great creator to look after our children, all our children. And when I say all our children, I include the people that calls themselves Canadian. I include everybody, old stock and new stock. I also pray for all of you here that whatever decision outcome, we can all come together and work it out. Honestly, work it out by absorbing the 7 teachings. And again, Kaniganijik, Ugumalkama, Mr. Webago, Oma, Kijagak, Ugavan, Wishkat, Mingwetneton. I also like to thank my old leaders of long ago. And the leaders, and I'm talking about chiefs, elders, who speak for us today. And when I speak to you folks, the old leaders, the old chiefs, who did not know a word of English, I speak of my granny and my grandpa, who did not speak English, who were considered illiterate, but they were not. Our old leaders were not. Right across this nation called Canada, Turtle Island, from the hearts. And every morning, every day, when I have a chance and given the honor to speak here in other situations, they're always in here, in the basis of my mind. I wish you well, folks. Thank you.
Thank you, Elder Sekani, for sharing your time with us and your stories, and for helping us wrap up this week's proceedings. So it's I appreciate that. To everybody else and to everybody watching, I wish you all good health to your families, and there will be a decision again at some point in a sooner rather than later fashion, and you'll be notified accordingly. So thank you very much. This concludes these proceedings.